that we propose is that the court itself should decide not only that the Speaker had a discretion, but that on the specific facts of this case, a secret ballot was warranted. So it is not a matter of remittal, but it is a matter of complete substitution. So that sets the framework of what I propose saying this morning. So firstly, let's delineate the outer limits of the discussion on the structural question about how the Constitution ought to be interpreted. So the starting point, and I think this is a point that Justice Ngabinde makes, is reference to Section 42 of the Constitution, particularly the obligation that is imposed on Parliament. So according to this section, particularly Section 42(3), there are three functions that are assigned to Parliament. So it is to choose the President, it is to provide a national forum for public consideration of issues by passing legislation, and then here is the important one, scrutinizing and overseeing executive action. This case is ultimately about overseeing executive action. And we know this from the Mazibuko judgment. We know that a motion of no confidence in its nature is a form of holding the executive accountable. In fact, I think Justice Museneke in that case says that it is the ultimate form of holding the executive accountable. So this is an important entry point into the case, is to understand the nature of the function that the Parliament is being asked to perform. It is a function of holding the executive accountable, scrutinizing their conduct, overseeing their conduct, and ultimately, when they fail, booting them out of office. Now, the reason why this is important to highlight upfront is because it illustrates quite clearly the sort of tension that our learned friends for the President, I think, referred to. And we don't criticize them for highlighting the tension because it is a real existential tension. And this is a point that is made also in the UTM case and also in certification. That sometimes there is a dictate of the party. The party wants its members in Parliament to behave in a particular way. But the members of Parliament are bound by the Constitution to follow certain rules. Now here, it is the most illustrative instance where a party that is the majority in Parliament must oversee its own representatives in Parliament. So here we see at its most extreme form why the duty imposed on members of Parliament, members of the National Assembly, why that duty becomes most profound. So we're dealing not only with the ultimate form of holding the executive accountable, but also with the point that illustrates precisely the point at which the clash between a party loyalty or a party mandate and the duty towards the Constitution arises. So here we say if the court is to adopt an interpretative approach, it is quite clear that there is no choice. Because the Constitution imposes an obligation on members of the National Assembly to hold the executive accountable, here they have no choice but to follow the Constitution. So that's the first point that we say is vital to point out. It is the significance of Section 42 and the imposition on members of the National Assembly, and how that imposition ultimately trumps all considerations, including considerations about party discipline. The second point that we must frame in relation to the structural construction of the Constitution is the entitlement or the right. Mr. Unterhalter will develop the right around Section 19. I'm not going to argue the case on Section 19, but inside the National Assembly itself, members are entitled to vote according to personal conscience. That has now crystallized into a constitutional principle. We know that from at least 3 decisions, 2 of this court and 1 decision of the Western Cape High Court. So the first decision that illustrates the point that members of the National Assembly are entitled to vote according to personal conscience is the certification case, particularly paragraph 186. The Chief Justice and the members of the court will recall what was at stake in that case. It was a question about whether or not it was proper for the Constitution at the time not to provide for anti-defection. The criticism was that the idea that a member of the National Assembly may not defect from their party ultimately makes them subservient to the whims and the idiosyncrasies of the party. And the court finds that that is not so. The fact that a party nominates a member to sit in parliament does not take away the discretion of the particular member on any topic before them to vote according to personal conscience. In fact, the question is answered in very unequivocal terms. An individual member remains free to follow the dictates of personal conscience. So we know it to be a matter of constitutional principle that each and every member in the National Assembly, regardless of the wishes of their political party, may vote on any topic according to their personal conscience. And the second judgment is factual. Admittedly, factual dealt with the local legislative sphere as opposed to the national legislative sphere. But factual makes the point clear in paragraph 41 of factual, where it says each member is entitled to his or her own reasons for voting for or against any resolution and is entitled to do so on political grounds. So each member, of course, may take into account the wishes of their political party, but remains, in a sense, autonomous to decide what to do on a matter that is presented before the local legislative assembly. The same principle applies in relation to the National Assembly. And then the final judgment is Van Zyl, which we cite in our heads of argument, and where, again, the point is made quite clearly, and there it was a motion of no confidence in relation to one of the members of the provincial legislature, where the court says it is recognized that the individual members thereof, individual members of the party, retain the right to follow... Where
are you reading from? Just which paragraph?
Sorry, Chief Justice, it is paragraph 45. The judgment of Van Zyl, I can't remember the judge, I think it's Van Rienen. But what he says is that it is recognized that the individual members thereof retain the right to follow the dictates of their own conscience. Viewed from that perspective, the vote of any individual member constitutes an articulation of his or her own view of how the question posed in the motion should be responded to. We've looked at the heads of argument filed by our learned friends for the President and the Speaker. There is no counter to the proposition that members of the National Assembly are entitled to vote according to their personal conscience. And there's no answer to any of these three judgments that we've cited. Then the third proposition that I want, in addition to Section 42, and as well as the entitlement, the right to vote according to personal conscience, is the duty, the obligation. And the duty or the obligation of members of Parliament is primarily to the electorate and to the Constitution. So that is their primary duty. That duty is most pronounced when one deals with holding the executive accountable, particularly if you are a member of the majority party. We know this, we've already referred to Section 42.3, but we also know it from the affirmation or oath that is taken by the members, because there they affirm to obey, respect, and uphold the Constitution. We also know this, and this is, I think, a point that is made by Mr. Katz, from the preamble of the Powers and Privileges Act, that the intention of that act is to protect the authority, independence, and dignity of the legislatures and their members. And we also know it from the Ngcukaitobi decision that was penned by the Chief Justice. So we know at least three things that should form the subject matter of the discussion. We know the entitlement of the members to vote according to conscience. We know that they not only are entitled, but they are obliged to do what the Constitution requires them to do. We know that they are not subservient or machines to carry out party mandates. In fact, their duty is agents to serve the public as a whole. So my fourth proposition then builds on these 3 points that I've already laid out, which is this: when one interprets the Constitution, and this is the point I think Justice Froneman raised with Mr. Mpofu, when one interprets the Constitution, one must do so in order to fulfill these 3 principles that I have referred to. Or at the very least, one should not adopt an interpretation to the Constitution that will frustrate the ability of members to vote according to conscience, or that would frustrate the ability of members to hold the executive accountable. And that applies whether one is a member of the EFF or whether one is a member of the ANC. The fact of the matter is that one cannot adopt an interpretation to the Constitution that will not make it possible for members of Parliament to perform their primary constitutional obligations, which is to the Constitution and to the public as a whole. So the construction then that one places on the question of whether or not the Speaker had a discretion is a construction that must be consistent with the overall purpose of the Constitution. And these are the two primary, most important purposes of the Constitution that I have already set out above. So, what do we then say about the question before the court? So we say that on the issue of the discretion, the Speaker is clearly mistaken when she takes the view that she has no discretion to allow voting by a secret ballot. And it does not matter, Chief Justice, that at the time she made the decision, she was bound to follow the full bench judgment in Taumana, because the fact of the matter is that the court must look at the law objectively and make a pronouncement on whether or not, as a matter of constitutional interpretation, the Speaker does have a discretion or doesn't have a discretion. So we submit here that it's clear that the combined effect of Rule 103 and Rule 104, that the Speaker is entitled to decide the procedure that must be followed in relation to a voting, in particular, a no confidence voting in the President. Now, what that leads us to is, of course, Section 102 of the Constitution. Because here there is an issue about, well, is there an exclusion? It is clear, according to certainly the submissions made by Mr. Mpofu, that there is no exclusion. What is an omission. But the question of how one engages with that omission is a question of structural interpretation of the Constitution. And the structure follows the purpose, and we've already set out what the fundamentals of that purposes are. So, in other words, this is not a discretion in the air. This is not a discretion to allow a license for a liquor trading license in a township. This is a discretion to enable members of Parliament to perform particular functions. It is not a discretion to do whatever the Speaker wants to do. It is, in a sense, a limited form of a discretion. It is a discretion that has a clear goal in mind. So one cannot assert a discretion where asserting the discretion ultimately reverses or frustrates the constitutional obligation. So the Speaker, it is true, has a discretion, but that discretion must also be understood in the context. I think we cited it in our heads of argument, in the first set of our heads of argument, in paragraph 8.1. The Speaker's discretion is a discretion that enables her to enable the National Assembly to allow the members of the National Assembly to perform their functions under the Constitution. So what is critical in paragraph 8.1 of what we say in our heads of argument is that Section 26 of the National Assembly rules, and this is what we cite here, it confers a number of obligations on the Speaker. The first one, in exercising the authority of the Speaker...
I didn't hear the section, and your 10 minutes
26,
is up. 26,
Chief Justice. Yes, sorry, I had forgotten that I had put a stop to my interrogation, but yes, I have no difficulties, unless it doesn't seem there's a question yet. So it's Section 26 of the National Assembly rules. What it provides for in Section 26.1, in exercising the authority of the Speaker as provided for in the Constitution and legislation and the rules of Parliament, the Speaker must, and this is A, ensure that the National Assembly provides a national forum for public consideration of issues, passes legislation, and scrutinizes and oversees executive action in accordance with Section 42.3 of the Constitution. So what we see from Rule 26 is a domestication of the broad constitutional obligation, that even when the Speaker exercises her discretion, she must do so to enable the National Assembly to perform its primary constitutional obligation. So now...
I'm sorry to interrupt at this stage, Mr. Ngcukaitobi. I just want to understand clearly, where does this discretion come from? Does it follow... Earlier, Mr. Mpofu was asked a question by my brother, Justice Yafta, whether Parliament and the Speaker acting in terms of that doesn't have the competence in terms of Section 57 to determine its internal arrangements. Does her discretion then follow from that or from some other source?
Yes, we accept Section 57 that they are entitled to decide their internal measures. What is an issue here is what are those internal measures? Because they do so when Parliament acts in the form of rules. They have already decided the rules. The rules themselves allow them the discretion. And Rule 103 and Rule 104 allows them the discretion. Rule 26 prescribes what the purpose of that discretion is. It's not a discretion in the air. So we submit that if the court explains to the Speaker that she has a discretion, the court does no violence to separation of powers. The court does no violence to Section 57 of the Constitution, because the court recognizes that insofar as that internal authority of Parliament, Parliament is king. But insofar as what that means, the judiciary is king. Now, now we know where we stand, that not only does she have a discretion, because it's explicitly provided for in Rule 103 and 104, we also know what the purpose of that discretion is, because we see that from Rule 26, that the purpose of the discretion...
Let me understand the discretion. I'm sorry, Mr. Ngcukaitobi.
Yes, Chief Justice.
Are we to accept that the Rules Committee reflected on but decided against a secret ballot in relation to motions of no confidence?
No, Chief Justice, we simply cannot...
We are not to accept that?
No, we must reject the proposition.
Okay. It
is a proposition unfounded on the text.
Yes.
To the contrary, what the text ultimately does is to leave the question open.
No. I'm asking a slightly different question. My understanding of the Speaker's position is this: that political parties represented in the National Assembly had occasion to reflect on whether to make provision for a vote by secret ballot when either a motion for impeachment is considered or a motion of no confidence is considered. I'm asking whether that is to be accepted as a fact. Did that actually happen or not?
Chief Justice, we should reject it if the only evidence... Sorry, Chief Justice, it looks like you have a follow-up question. Sorry. If the only evidence is manifested in the rules, and I make the argument that ultimately the National Assembly functions through the rules, if the only evidence is manifested through the rules would have obviously prohibited a voting by secret ballot. On a proper construction of the rules ultimately leave the question open. But we cannot accept that by implication there has been an exclusion in the rules themselves.
I'm not there. I'm elsewhere. I'm saying, did occasion arise where where political parties represented in the National Assembly asked themselves a question: isn't it necessary to make provision for voting on a motion of no confidence against the President by secret ballot, but that did not materialize?
No,
because then that would lead to another question, which would be, how can the Speaker then find it possible to go against a position that she knows the collective has rejected?
Yes.
But if you tell me that we are not to have regard to what she says, it's not correct, I'm happy with the answer.
Yes, it is incorrect, Chief Justice. I think I now understand that the question has been asked 2 times, so at some point I must come to the understanding. So, on the first point, Chief Justice, we should reject it. I mean, there is nothing on the evidence that proves that point at all. Yes. The Chief Justice presumably understands my primary argument that on the construction of the rules, the question is ultimately open. But it is not open-ended because of Rule 26 of the National Assembly rules.
Would we arrive at a conclusion based on the rules, regardless of what we understand the Constitution to be requiring of the National Assembly, yes, or the Speaker? Or is our starting point Section 102.2?
Yes.
And only thereafter can you begin to say, because this is what the Constitution means, properly understood, this rule then means this.
Yes, Chief Justice, that's correct. And this is now the next point I want to deal with, which is this. The points we've made about the entitlement to vote in accordance with personal conscience, the point we have made about Section 42, all of those factors play a role in how to interpret the rules and how to interpret the conduct of the Speaker. But then there is Section 102, and this is now my next point. It's Section 102 that deals with the question of the removal of the President by way of a vote of no confidence. So the starting point here is not to make, and I think the point is that we are being accused of making a linguistic jump between Section 102 and Section 86. When we cite Section 86 of the Constitution, I now make the textual argument. When we cite Section 86 of the Constitution, we don't ask the court to superimpose the procedure in Section 86 in place of Section 102. What we say are three things about the significance of Section 86 and the procedure that it prescribes. The first is that the constitutional text itself contemplates that in the event of a contested election of a president, that contest must be resolved by a secret ballot. The second point that we make is that the sole justification, we have not seen anything in our learned friends' answering affidavit and in their heads of argument, contesting the suggestion that the sole justification why the contestation of the election of a president must be conducted by a secret ballot that is not intended to protect the personal conscience of the members of parliament. If members of parliament are entitled as a matter of law to vote according to their personal conscience, the only logical explanation why Section 86 requires a contested vote of a president to be done by way of a secret ballot is to protect the personal conscience. No contest is taken with that proposition at all by our learned friends. The third reason, and this is the reason that Justice Cameron was texting Mr. Mpofu about, the third reason is the inseparability between the office of the president and the person occupying that office. Why members of parliament must exercise their independent judgment to bear is because not only should they simply take for granted whoever is proposed by the majority party, but they themselves must reflect whether or not the person who is about to be entrusted with the most important office in the country is in fact suitable. And from that perspective, they are entitled to then bring their own independent judgment to bear. We know this, the point that Justice Cameron made about the inseparability between the office and the person, also from your own judgment, Chief Justice, in Ngandla, in paragraphs 20 and 26, where the Chief Justice explains what the responsibilities, and perhaps if I could cite in paragraph 20, the President is the head of state and the head of the National Assembly. He is indeed the highest calling to the highest office in the land. He is the first citizen of this country and occupies a position indispensable for the effective governance of our democratic country. Only upon him has the constitutional obligation to uphold, defend, and respect the Constitution as the supreme law of the Republic has been imposed. So what we see from Section 86 is that the logic why Section 86 specifically says once there is a contestation, you must now be free to exercise independent judgment, also implicates the personality of the president and not just the mere fact that they've come from a particular political party. And so what we say then from that comparison with Section 86, we obviously don't make the language leap that Section 86 must simply be imposed. But what we say is that the logic underlying Section 86 applies with equal force to Section 102 of the Constitution. What members of Parliament are now being asked to do by the UDM, or I think the DA also has made this proposal. What they're being asked is you must decide, apparently the IFP has done the same. What they are being asked is that you must decide a most contentious question. Is this man fit to remain in office? What they're being asked to do is that they must do so by reference to their personal conscience. What they are being asked to do, as according to Justice Museneke, is that they're being asked to decide on the ultimate form of holding the executive accountable. So one can never separate the question about the personal integrity of the man occupying the office from his constitutional obligations. So in those circumstances, we say there is at the very least a comparable scenario, because once one accepts the logic beneath or behind Section 86, one must inevitably come to the conclusion that in the event, as we have shown, that the rules are silent on the question or the rules are not exclusionary, the most logical way that promotes the value of holding the executive accountable and the most logical way that promotes the value of personal conscience of members of parliament is a secret ballot. And by the way, Chief Justice, the idea of a personal conscience, although it has been raised pertinently by the UDM, has in fact not been contested by the Speaker and the President. So, and I come now to my final point on this issue. So, Chief Justice, what we ultimately submit is that once one looks at the structure of the Constitution and once one looks at the objectives sought to be achieved, and then one looks at the rights of members of parliament, it seems inevitable that not only was the Speaker wrong in refusing the discretion, what is also inevitable is that the only way that this discretion on these facts had to be decided is by allowing a secret ballot. Otherwise, no motion of no confidence, particularly a motion as contested as this motion, in fact, can take place effectively. And we are not concerned here, and I know the President criticizes us about this, we are not concerned here with the outcome. It does not matter whether or not members of parliament ultimately decided to retain President Zuma. What we are concerned is the conditionalities that must be present for the effective exercise of personal conscience. And the argument that is being made is that the only conditionality that is not only constitutionally warranted, but also obligatory, is that the members of parliament must be free to decide for themselves. Whether they are members of the ANC actually makes no difference. The fact of the matter is they must be free to decide whether this man is in fact the true embodiment of the spirit of the Constitution.
Why won't they be free otherwise? I haven't heard you touch on that one.
Because for the reasons that have actually been articulated by the President himself, is that ultimately, if one has to draw a comparison between these two scenarios that I have pitched, is that if one accepts as truism my suggestion that in order to exercise personal conscience, you need some protection from what? You need the protection from any possible repercussions of the exercise of your personal choice. And we know this open voting ultimately exposes each and every member of parliament to these repercussions, which have not been hidden in this case. They have been explicitly pleaded by the President and are explicitly defended even in their heads of argument. So the only way members of parliament can be able to be free to exercise their personal conscience is if there is a judicial protection to party repercussions. And that ultimately is at the center of the problem. And here we are asking them, by the way, Chief Justice, in fact, to act in fulfillment of their constitutional obligation, sometimes contrary to the wishes of the party.
We have regard to what the parties say would happen or what the President says might happen should members of his party vote differently, or should we rather base it on the known rationale behind a secret ballot?
Chief Justice, I would...
Because just to clarify my position, it seems to be a bit problematic to say the President says. What if he hasn't said that?
Yes.
It doesn't quite help us to articulate the principle if it's based on either a threat or some looming repercussions expressed by some senior official of the ruling party. Isn't it better just to say experience has taught, based on whatever you can rely on, that they are likely to be, there is a potential for consequences that are undesirable for want of a better expression, and therefore?
Yes. I accept the suggestion, Chief Justice, without qualification. And I won't do the usual lawyer thing of saying I accept it, but I have something else to add. That takes me then to my... okay, well, Justice Kambembe.
Are you presiding now?
I'm sorry, Justice Kambembe. Let's go back to the Chief Justice.
Thank you, Chief Justice. Mr. Ngcukaitobi, the South African political system is based on the principle of accountability and transparency. Is it not anti-democratic to have such an important decision made by MPs voting secretly?
Yes. Justice Khampempe, we don't ask for a permanent principle. We ask for a limited principle that on these facts that we have, that the court has before them, it's inevitable. The mistakes made by the Speaker, the impossible conflict that she currently faces on this particular set of facts, it is almost an inevitable conclusion that this kind of a vote must take place by way of a secret ballot. There is another question that you are raising, which is, well, what do we do about the future? Parliament might respond to this in a variety of ways. The one is that it might domesticate this court's ruling into its own rules so that it decides how it should deal with motions of no confidence in the future. And that is what Section 57 ultimately is about. And so the court does not have to answer the democratic question as such, because that democratic question is itself assigned to Parliament as this place where the Parliament decides for itself what is the best method of incorporating the principles of democratic participation and accountability. So to that extent, that is the correct space where that debate ought to be taking place. So we would submit that a limited decision on these particular facts, in fact, does no violence to the democratic principles of openness and accountability. Chief Justice, I think I can now pass the mic
Well, it's my brother Jafta's turn. Once he's done, I want a signal from him because I really want to understand this temporary solution that you are contending for. But to my brother first.
Yes.
Sorry. You commenced by drawing our attention to the rules.
Yes, Justice Drift.
And you moved to the Constitution.
Yes.
Would I not be correct to say the starting point should be the Constitution? And you may move to the rules if the Constitution is deficient in some respect. The reason why I'm raising this, I'm not clear on the basis of your argument as to where you locate the discretion. Is it in the rules? Is it in the Constitution interpreted in the manner that you have articulated? Or is it in both?
Yes, I would suggest, Justice Jafta, that I'm asking for a combined, so on the starting point, I think it's just the way I presented the argument, but I accept your argument in terms of the hierarchy of interpretation. It's quite clear that one starts with the Constitution. But I start there as well. I start from Section 42 of the Constitution. I say we start with the object that the rules serve. The rules don't exist for themselves. They serve a particular purpose. So the purpose is Section 42. So whatever construct one places on the rules is a construct that not only must be consistent, but must also fulfill Section 42. And so here what we have is that where there is a linguistic gap in the rules, that gap will suggest that the court should in fact deal with it by way of interpreting what the object of Section 42 is, and therefore what the object of the rules ought to be in the light of Section 42. But then you ask me a second question, which is where we locate the discretion. I suggest we locate the discretion in a, sorry, just after, yes. I suggest we locate it in different places in the Constitution. I mean, earlier on, Chief Justice spoke about Section 55 of the Constitution, which is an important section because that was the section in which this court asserted its exclusive jurisdiction in relation to the EFF case. But it's important also because it defines the role of the National Assembly, because in Section 55(2)(b), the National Assembly must provide for mechanisms to maintain oversight of the exercise of the national executive authority, including the implementation of legislation. So the rules, in fact, are intended to be a mechanism to maintain this oversight. And if one looks at the rules themselves, so the rules must make provision for this. If one looks at the rules themselves, the text of the rules, clearly, I mean, if one looks at Rule 103(1), it says, unless the presiding officer directs otherwise. If one looks at Rule 104(1), with a procedure determined by the Speaker and directives to be announced by the presiding officer. So,
at the level, I'm sorry to interrupt you, at the level of interpretation, what I want to appreciate is whether, when one follows the interpretative process that you have advanced, does one reach a conclusion that the Constitution itself, read in context with Section 86, requires that motions of no confidence in Section 102 must be dealt with by secret ballot without adding the rules?
Well, what I suggest, Justice Jafta, is the rules are important insofar as the question of the discretion is concerned. The rules make it clear that you have a discretion, but I suggest that the way in which that discretion ought to be exercised is an important constitutional question. The way to interpret how that discretion is to be exercised is by then having regard to the Constitution.
Shouldn't then we draw a distinction between the genesis of the discretion and the manner in which it has to be exercised?
Yes, Justice Jafta, I accept that.
Is the genesis the Constitution and the rules regulate the manner of exercising it?
Yes, that is correct, Justice Jafta. Thank you.
If the rules were not there, what would you say?
Justice Mogoeng,
I know they are there, but if they were not there.
Yes. Chief Justice, well, there could be a number of, there are the more serious answers to the question and then the less serious answers. Maybe I should focus on the serious answers. So first, the Parliament has no choice but to make these rules. But I would suggest that even in those circumstances, on my structural construction of the Constitution, I would still suggest that if one looks at the logic behind Section 86, that logic equally applies to Section 102. I simply say that as a matter of pragmatism, the court need not necessarily reach a question which it does not have to reach to get to an outcome. There is a lower level way of addressing the question that is before the court, which is the discretionary argument, and the discretionary argument coupled with a substitution order. So if the rules were not there, I would suggest that the argument that Mr. Mpofu advanced is in fact a good argument for the reasons that he advances in relation to how Section 102 should be read together with Section 86.
Why do you want an interpretation that caters for the now and not for all times? And how do you get there? Why do you want a solution just to deal with this case?
Yes. Well, Chief
and
Justice,
not an interpretation that will always be available for whoever wants to move a motion to employ? Yes. Or to resort to?
Yes.
I don't understand this.
Well, Chief Justice, the interpretation I have advanced to the court is an interpretation for now and the future. Let's confront the problem. It's the interpretation for the now and the future. All I say is that...
I thought you said you're not asking for a permanent principle.
Yes, no, Chief Justice.
Is that not what you said?
No, on the interpretation, I suggest that I'm simply saying that the court does not have to decide other cases.
No, please let me just get this one right, because that's why I said once Justice Jafta is done, I would like to come back to you to this issue. Was it not the position you articulated that you're not asking for a permanent principle or a principle that will always be available to be resorted to in dealing with matters of this nature? You want a solution for the current problem. Is that not what you said?
Well, Chief Justice, that is probably what I said. I can't remember the exact words, but the Chief Justice...
The effect, is that was it to the same effect?
Yes, but let me just clarify, because now that I have a chance to clarify where I stand on the matter, I should. Now, Chief Justice, what I do suggest about the interpretation, it's impossible in any event to advance an interpretation that will apply to Mr. Jacob Zuma's removal, but not apply to Mr. Malema's removal. The fact of the matter is, or Mr. Musa's removal. Yeah? But the fact of the matter is that if I'm right in my interpretation, it will apply to everybody. But the distinction I'm trying to draw, maybe too fine a distinction, is that the court does not have to decide future cases in relation to how the Speaker's discretion might be exercised. And one can think of a number of instances that might arise.
Please allow me to interrupt you. Here is where I am, Mr. Ngcukaitobi. I thought all we have to do is interpret the Constitution and, to the extent necessary, the rules, and say, this is what the Constitution properly interpreted means.
Yes.
This is what the rule or the rules properly interpreted mean. Whether you use them or not is none of our business. We're simply interpreting so that there is clarity in relation to the meaning of the section or the sections or the rules. That's it.
Chief Justice, I accept
So
that.
I wanted to clarify this permanent principle statement that you have made.
Chief Justice, I accept what you have just put to me. And insofar as I try to draw a separation between another set of facts, the fact is that those facts are not before us and they don't have to be entertained. So I accept the proposition that ultimately the court must interpret what the rules mean and it must interpret what the Constitution means. I have advanced an interpretation and its justification. And who uses it in the future is up to future generations.
Are you saying that the Speaker is permitted to have a motion of no confidence conducted by secret ballot, or are you saying the Speaker is required to have a motion of no confidence conducted by secret ballot? I'm not too, I think you're saying she is permitted, she may. I'm not too sure. I just want certainty as to what your submission is.
Well, I make two submissions here, Chief Justice. The first is that she is clearly permitted on the text of the rules. Once the text of the rules is subjected to my constitutional analysis, she is in fact obliged. And I'm asking the court to find that the Speaker was in fact obliged in this case to ensure that it was conducted by way of a secret ballot.
On which section do you hinge the obligation as opposed to the permissibility?
Yes, I hinge the obligation firstly on section 42(3) of the Constitution. I hinge it next on section 55(2)(b) of the Constitution. And I have referred to the jurisprudence of this court in relation to personal conscience, and I have also hinged it on the comparability of section 86 and the underlying logic of section 86 and read together with section 102. Our submission is that you have to read section 102 and schedule 6 together with section 86.
Ngcukaitobi, do you add to what you've just told the Chief Justice any specific facts that you want us to look at? Or are they abstract facts? Or are you going to get real down close, slow and dirty and tell us what you want us to take into account?
Justice Cameron, there are some facts that can be taken into account which are sort of in the middle between the abstraction and the real and the dirty. The one important fact is the supermajority enjoyed by the ANC, which is common cause. The second important fact is, again, the uncontested fact about the threat of party discipline. The third fact, which we say in our affidavit, is the fact that at least one MP has publicly said that she should not be required to follow an injudicious leadership. But she finds herself in an impossible bind because of party instructions. Those facts, excluding questions of intimidation, those facts alone are sufficient to enable this court to get to my conclusion that once one looks at these particular facts that are applicable here, and that's why sometimes I'm reluctant to anticipate what the future might look like, but I suggest that these facts show how heightened the obligation that is imposed of the
So you're really asking the court to say that the Speaker's discretion in the light of the constitutional imperatives and the structure of the Constitution you've set out is very narrow. If there's any situation in which the Speaker may have reason to suspect or fear that there will be dictation or intimidation, let alone threats, it's a very, very narrow discretion, a mere trigger and the Speaker should say, we're going to have a secret ballot.
Yes, indeed. And I do suggest, Justice Cameron, that the Speaker might, in the light of this court's judgment, decide to make a specific provision. I mean, as someone was saying to me, in other jurisdictions, 20% is enough to trigger a secret ballot. But that is a different issue. But on these facts, that should have triggered a secret ballot.
I'm sorry, Mr. Ngcukaitobi. Just for clarification, the Chief Justice just asked you about whether you say the Speaker is required or permitted to ensure that it's the secret ballot that is used. You have given a certain answer to that question, but that answer appears to me to be possibly inconsistent with the stance you announced when you started. When you started, you said you supported the submissions made by Mr. Mpofu. Mr. Mpofu said his primary argument was that the Speaker was required. His second one was that, as an alternative, the Speaker had a discretion. Does that mean there's been a shift on your stance, or is it the same thing?
Justice Sono, I'm trying to recall what Mr. Mpofu said. The last
when you stood up, you were quite clear about what he had said.
The last thing I want is to disagree with him. Justice Sono, I don't know what the consequences, but I suggest that the answer that I'm trying to give is as specific as possible, is that she, insofar as she says that she has no discretion, she's mistaken as a matter of law. I submit that it goes beyond a discretion. She is, in fact, obliged in this case. Now,
by the facts, you mean?
Yes, she is obliged by these facts and by the objectives that I have articulated to the court.
That I understand. I understood yet that to be your answer to the Chief Justice's question. Yes. But what it raised in my mind was that being obliged that you are talking about now is different from the being obliged that Mr. Mpofu was talking about. Mr. Mpofu was saying, if you interpret the Constitution properly, the conclusion you must arrive at is that the Speaker is obliged. If you are not with me on that, that's what he was saying, then my next argument is the Speaker has a discretion. Yes. But what you have just said doesn't seem to me to say exactly the same thing. And all I'm asking is clarification whether you just want to focus on the discretion or whether you are still also pursuing the Mr. Mpofu's primary argument as well.
Yes, thank you, Justice Sonda. I think I now understand. My primary argument was on the discretion, and I have used the text of the Constitution and the comparators to support the primary argument, and in particular to support the relief that it is inevitable, foregone conclusion that here she should have allowed a secret ballot. I presume Mr. Mpofu will have a chance to reply, so he can decide for himself whether I have agreed with him or I haven't agreed with him. So I'll leave it at that. Yes.
Mr. Ngcukaitobi, would it be correct really to speak of a discretion? If the Speaker is obliged on the proper interpretation of Section 102, read with other sections of the Constitution, to have a motion of no confidence dealt with by secret ballot, can we term it a discretion?
Yes, I mean, when I commenced, Justice Tafta, I said it was a very limited form of a discretion. And I mean, I suppose it is simply the absence of the limited words that you can use in the English language, unlike in Xhosa. But it's an attenuated form of a discretion.
Is it a discretion at all? That's my problem.
Yes,
if the Constitution says, in order to serve the purpose of Section 102 and eliminate any potential risk,
yes,
the voting for a motion of no confidence must be by secret ballot. What discretion is open to the Speaker?
Justice Tafta, yes, I agree.
No, Mr. Ngcukaitobi, On a lighter note, I thought I had experience. I've always experienced you as a man who speaks directly and with clarity. So I'm begging you to speak with clarity now. Is it reasonable to assert that the public vote, as permitted by Section 19(2) of the Constitution by secret ballot, to protect them from possible unpleasant consequences that could be meted out to them by those who were expecting them to vote for them, but now know that they didn't? Is it fair to say that? You're protecting, you don't want anybody to know that they didn't vote for this one, they voted for that one, therefore you protect them. Is it fair to make that assertion?
Yes, it
Right.
is.
Okay. Can I move on? Or
Yes.
I just wanted a yes, but if you want to articulate, I don't want to treat you like a pupil.
I need to hear what the question is.
Yes.
Yes.
All right. Now, is it fair to extend that logic or that rationale to voting for a president? Let me explain what I'm talking about.
You mean MPs voting for the president?
Yes. You see, when there is no other candidate, what are you wasting your vote for?
Yes.
There's no contestation,
Yes.
no show. So the presiding officer declares. But if there is more than one candidate, they may even be coming from the same political party,
Yes.
or a combination of those possibilities.
Yes.
And just in case you were told by somebody that you relate very well to or somebody superior to you to toe a particular line, it appears, broadly speaking, that Schedule 3, Part A, Item 6A, seeks to protect the identity of the voters.
Yes.
It shouldn't be known who of the many possibilities you voted for, so that you don't attract
Yes.
undesirable or unpleasant consequences.
Yes.
That seems to apply to that situation, isn't it?
That is true, Chief Justice.
Let me take it a step further. Now, the choice in terms of repercussion, or the seriousness in terms of repercussions between, and that addresses the need to protect or the need not to protect, between voting for a person who's just entertaining a hope.
Yes.
He or she likes it,
Yes.
and is hoping to enter,
Yes.
but does not enter because certain people did not vote him or her into office. Contrast that with a person who's occupying now,
Yes.
sitting majestically there with all the power and the benefits and everything that comes with it.
Yes.
Now you want to drag the person out of the seat
Yes.
and out of the benefits. Where do we find more risk?
Yes. Chief Justice, you've spoken with even greater clarity than you know me to do. But Chief Justice, this is precisely the point, is that once one looks at the nature of the function being performed, it is not just an ordinary holding of the executive accountable.
No. Please answer my question. I'll follow with the rest.
Yes.
Where does the risk lie the most?
It lies the most in the removal,
In the removal.
particularly because of the likelihood of the removal failing. And that is the problem at issue, because one never knows what the removal ultimately will achieve.
Right. Now, and that is because the removal holds a lot of humiliation, isn't it?
Yes, Chief Justice.
Not just for one person, but for a whole host of people.
Yes.
If it succeeds. It's humiliating. It's painful.
Yes. Indeed, Chief Justice.
It is the worst thing you can ever wish for your for your enemy, for want of a better expression.
Yes.
So why then is it a permissible as opposed to a required, I don't want to say option, method? Why is a secret ballot then, according to your primary position,
Yes.
permissible and not required? You see, we want to sit, when we sit down now to consider judgment, we want to have the benefit of your input. Why are you saying it should be a discretion and not something obligatory? You don't have to say it. I want to understand the logic.
Well, Chief Justice, I must give you my understanding of it. What we do suggest is that if this is a discretion properly so-called, I mean, one looks at the rules. The rules sort of contemplate a permissible atmosphere. But what we ultimately suggest is that there is absolutely no way in which the objects of the Constitution can be achieved other than by a secret ballot. And the Chief Justice has actually put the finger on the problem. What happens when this vote of no confidence fails? And this is the problem. The only way that the MPs can be protected in a manner that enables them to vote according to their conscience is a secret ballot. So insofar as you have a limited form of a discretion, which this is how I've termed it, a limited form of a discretion, it is a discretion that must be exercised in a particular way to achieve particular objects. And I've set out what those objects are. So I would contest this sort of open-ended nature of a discretion and suggest that if there is any discretion, it's a very, very limited form of a discretion. So that's as far as the question of the discretion. It's a limited form. Perhaps we can find another word for it.
To sum it up, your primary argument is that the National Assembly or the Speaker has a discretion, and your fallback position is that the Speaker is obliged. Am I mischaracterizing your position?
No, Chief Justice. What I do say is that the text of the rules, yes, the text of the rules do not prohibit. The speakers came to court saying, I'm prohibited, I have no discretion. The text of the rules do not prohibit. In other words, it's permissible. But I suggest that when one looks at the current case before the court, it is obligatory. And so I have no alternative argument on the current case before this court. My primary argument is it was obligatory, not just to permit, but to ensure that the voting takes place by way of a secret ballot. It was an obligatory requirement in order to fulfill all of these objectives of the Constitution. Sorry, what should I say? No, but I mean... the Chief Justice, I think I've said most of the things I wanted to say, and I think I've also been allowed more time than I was entitled to. Unless there are any pressing issues, I'm tempted to allow Mr. Katz to take over.
Thank you very much, Mr. Ngcukaitobi. Thank you.